Hey guys, and welcome to the weekly docket. Hey guys, good morning on a Friday morning, and let's see what kind of weird things have been happening. I had to put these slides together pretty quickly, so a lot of this will be as much a surprise to me as it might be to you. So let's see what we've got. There have been some developments in cases. All right, let's see here. Let's talk about Darrell Brooks. Not much, but still something, which is interesting. And that is, if you recall, on his Erica Patterson related charges, his attorney has filed a motion to dismiss. Now, in this case, he only had one attorney of record. You can see that up at the top. And that attorney has filed a motion. Sorry, not motion to dismiss. I think I just said that. I need more coffee. He's filed a motion to withdraw. So he wants out of the case. And the assumption people are operating under, which I think is a good one, is that Brooks wants to self-represent and go pro se again. I think that's probably right. I think that's probably why they continued this case after the shooting charges. Now, this case was originally set for trial after the delay on August 14th before a male judge, Judge Hanrahan, and people were like, well, how's he going to behave with that male judge in a trial versus a female judge? Then, of course, that got derailed because it got changed from a trial date to hearing the motion to withdraw. But now, if you look at this, they have changed the docket again, and they are putting the motion to withdraw back in front of Judge Havas, who has been handling this case, the earlier hearings. So however he's been behaving with her might be the way he continues to behave. I don't think he'll be as oppositional as he was in the parade trial, because he wants to secure the ability to represent himself here. We'll just have to see. But the idea of whether he would behave differently with a man in a trial, I don't know that that's going to happen. It would have to change again, the assignment, because it's back to the judge that it had been with. So that's that on him. And we can leave him be for the moment. Kohberger, I posted this last night, and you've probably seen it either there or on other sources, has updated his alibi defense from no alibi, which again is reasonable if you're a single dude living alone and a crime occurs between, say, 2 and 4 in the morning. Who's going to be able to establish your alibi for you if you're not with anybody? So I don't think the lack of an alibi suggests that he's guilty at all, right? However, if you say you have an alibi, then what the hell is it? Well, he's updated that, and here it is. Mr. Kohberger has long had a habit of going for drives alone. Often he would go for drives at night. Okay. He did so late on November 12th and into November 13th. He's not claiming to be at a specific location at a specific time, and there are no witnesses to help him with that. But he was out driving during the late night and early hours. Now, why would he say this? Of course, he might say it because it's true that he went out and drove around and came back home. He might also say it because he drove out that night, and they have a pretty good video from the apartment complex he was living in of his car leaving and coming. You're not really going to be able to dispute that. So now he's admitted to being out and about away from where he lives the night of the murder. And maybe he did that before, and maybe he innocently, drives around at night to relieve his anxiety or whatever. Or maybe he was reconning what he was going to do. But I don't think this, in terms of an alibi, it's not really so much an alibi. You're basically just saying, I was anywhere other than the scene of the crime, but I can't tell you where I was, and I was in my car. I guess that's the alibi. Okay, that's fine. It's not a strong alibi, right? Again, I don't think he has to have an alibi, but to me, this is worse than if he was at home sleeping, because now he is out of his apartment and out in the community somewhere, so he is available to have done this crime, and then you've got to continue to look at the other circumstantial evidence. So this is not exculpatory in my book. So we'll have to see. Granted, again, people can drive around late at night, and it's not always an indication of guilt. So, I mean, yeah, I get it. All right. So I was almost going to tell a story about when I got pulled over by the police late at night, and I was not guilty of anything other than trying to take some keys back to somebody. But it was very, very exciting because they were doing a stakeout and they thought they had the right guy. But I wasn't a Koberger style guy, so it wasn't. Okay. So let's see here. Here's a comment. But wouldn't he need someone or something to corroborate that story? Well, need is the operative word there, I think. I mean, if you believe him, he doesn't need anybody to do that. Now, having said that, let me relate this to this comment that's here, which says he has to tell them the alibi. That's correct. So if you're going to use an alibi defense in Idaho, then if the prosecution asks you to say what it is, then you have to tell them what it is. And if you don't do that, the sanction can be that you can't use the alibi defense except for your own testimony because you have a right to remain silent. So he could testify himself to establish his own alibi. Is he going to do that? I don't know. I mean, usually defendants don't testify, right? So if he's the only witness for his alibi, he would need to take the stand for that. So even if he broke the rules, say, and didn't tell what the alibi was, he still has a right to remain silent and then later on testify in his own defense. And even the prosecution, I think, admitted that in their brief. But their point is, if he's going to use other witnesses for that, the rules require that he declare those things, declare where he was and who's going to support that. So there we go on that. And here's somebody saying that Erica just said she's out and will not show up. So I'll have to check into that. I haven't heard that, but I know she operates her own channel, so that's cool. So, yeah. So anyway, I will tell this. So I was out driving late one night to take something back to somebody, and it didn't have my driver's license with me, but I was young, just out of the Army. I had a 45 in the car, a bunch of camouflage and stuff because that's still associated with the military. And I pulled over because this was before GPS, to figure out exactly which house I was supposed to deliver these keys back to related to work. And this car pulled up behind me, and two guys got out and had flashlights, and they didn't have any lights on or whatever. So I just watched them in the side view mirror, let them get up close to my truck, and then I took off. And then they started yelling and screaming and stuff. And pretty soon after that, there were lots of police cars with lights on, et cetera. And they pulled me over for real and asked me, why did you run from us? And I said, well, how am I supposed to know? You're the police. You didn't have any lights on. And they said, okay. And they said, well, I guess you know why we're pulling you over. And I didn't know that. And they told me the kind of criminal they were looking for. And I didn't have my driver's license, so that was uncomfortable for a little bit. But eventually I was let go. Now, they didn't find my DNA on a sheath under a murder victim, so I didn't have that to worry about. I know DNA doesn't matter and all that for people who want to choose to think that, but we'll see what the defense has to say about that. They're going to treat it like it does matter. Let's go to Richard Allen here, because there are some developments here in his case that I didn't see until I checked the docket. I didn't hear about, but 2 defeats for the defense in his case. And he's the man accused of killing Libby and Abby. A crime that occurred at the Monon High Bridge. You can see their pictures, and then a picture of that they took on the bridge that day, and then the scenes from a video they took of the person who was coming to kidnap them and used a gun to do that. The question is whether that was Richard Allen or not, because that's what the state has charged him with, is kidnapping them off of the bridge, and then that results in their deaths. Not charged with the murders by themselves, but as felony murder related to the kidnapping. So the state says, yes, that's him. His side says, no, it's not. They had a big blow up in this case because if you remember, the defense started saying, hey, he's being, basically in a POW camp. And I read their report and put it in a video a while back. And while some of it, I could see what they were saying. Some of it was like, many people every day live in conditions where like they overstated their case a lot, in my opinion, in terms of how bad it was. And they should have focused a little bit more. But then, while there were legitimate issues that they were talking about, or could be legitimate about their access to him and things like that, it also came out that he had confessed and made inculpatory statements on a recorded call with his wife, and apparently had done this more than once, or made more than one type of confession. So the defense is trying to say, look, he was out of his mind at that point, because look, those kind of statements can come in at trial. So that's bad. And this wasn't the police interrogating him. This was him talking to his wife. So naturally, of course, they would want to say that he wasn't in his right mind when he did it. So I think that also was something to do with this motion, in my opinion. But how did it work out for the defense? A couple of orders issued in July. One was the defendant's subpoena to the Department of Corrections, I think related to his mental treatment and stuff. They said that's unreasonable. The judge said it's unreasonable and oppressive and beyond the scope of discovery, so the subpoena is quashed. And so that means they can't get this stuff from the Department of Corrections that they were trying to do to establish this theory of I guess that, we want to know every time he talks to a counselor or something like that. I don't know, remember exactly what the subpoena was, but they're not getting it. So that was one defeat from the judge. But the next one, I think, was the more interesting one, which was he wanted to be transferred to a closer jail, which that made sense to me. He's in a high security environment and stuff. I could understand that. But I wasn't at the hearing. Guess who was? The judge. And this is what the judge said. The evidence presented at the hearing on defendant's motion to reconsider, and that's to reconsider the safekeeping order that was related to him, did not support many of the allegations advanced by defense counsel. In fact, the evidence presented demonstrated that the defendant is treated more favorably than other inmates housed at the Westfield Correctional Facility. In light of the evidence presented, the court has reconsidered the original safekeeping order and finds it is reasonable and necessary to ensure the defendant's safety and to prevent serious bodily harm to himself. The Department of Correction has provided and will continue to provide defendant with the necessary medical services, including mental health services. If the Department of Correction believes a facility other than Westfield is more appropriate or more convenient, the court is confident the Department of Correction will move the defendant accordingly. So they lost there. So they're in trouble in that case because they're behind the 8 ball at this point because he has made inculpatory statements on a recorded phone call to his wife, not in interrogation by the police. So you're not going to be able to say the police made you do it by pressure. You'll have to say, I just went out of my mind and said it. Well, how believable is any of that? I don't know because I haven't heard or seen the call and nobody else has either. So it'd be hard to have an opinion on it. But I can tell you that if you're defense counsel, you would rather your client not have confessed on a recorded call to a family member than having done that. So let's see. Here's a comment here on the Kohberger. The defense team is going down maybe this will work road. And maybe so. I think what they're really trying to do here, or tried to do to begin with, was just maintain the option of presenting an alibi if they could come up with one. Because when they originally said, we can't tell you what the alibi is yet because we have to look through all the discovery, I was like, what? I mean, an alibi is, hey, I wasn't there. I was here. And here's the evidence I have to support it, which might be myself. It might be me and this other person. It might be electronic information or data or whatever. You should be able to say that if you have an alibi. Otherwise, you're saying, I don't know if I have an alibi or not, man. I just don't know. So that's kind of what they said in the first one. We have to look through your stuff to figure out whether we have an alibi or not. And now they've advanced it, though, a little bit and said, well, okay, he was out of the house then. Or apartment. He was driving around at that time. That's going to be his alibi. So we'll see how that works. Maybe so. I still feel like that, it's an effort to maintain the possibility of an alibi, but it results in an admission at this point, which was one thing you do know now is he was not at home at the time these crimes occurred. So that as a potential alibi is out of the equation. He wasn't visiting relatives, family, camping somewhere. He was driving around, and they've basically said, we can't tell you where he was driving around. Not the world's strongest alibi, I feel like. So here goes Richard Allen, who I think probably is the right guy. I'd want to see all the evidence in context and things like that. There's some ballistic evidence, which is how good it is. Nobody can really say because no one has actually seen it, but it's certainly subject to dispute. And then there's the circumstantial evidence of his presence around the scene of the crime and how the time frame works. It looks really bad for him. You know what else looks bad for him? Confessing to your wife on the telephone. All right. So here's a comment here where I sat on a jury for a murder trial and defendant had a recorded prison call admission, found him guilty. Now, 2 years later, he's asking for a retrial. Yeah. Now I don't know the basis for that retrial. It might, I don't know the basis for that, but it definitely is bad if you were on the telephone admitting to the crime. That's not conclusive evidence, but it's some pretty strong evidence, right? So, Yeah. Now, if you're on a jail phone call, I don't think it matters who you're speaking to, a state property. And the point I'm trying to make here is that, it's one thing if the detective's browbeating you and, if you don't tell me, I'll go back, rip your house up again or whatever, pressure by the police or the 26th hour of interrogation. When you're talking to your wife on the phone, in theory, if you admitted you did this, why would you tell her you did it if you didn't do it? So that's what he's going to have to contend with. But yeah, absolutely. He's not going to be able to dodge the call being admitted into evidence. I do not think that's going to happen at all. That's a statement by a party opponent against his interest, and that's going to come in. It wasn't some private communication with his attorney. So there you go. So now back on Kohberger for a moment. Wouldn't his car have evidence that he was in the area of the murders? I've heard they can pull GPS info from the computers. That all depends. It really depends on how new that car is and the technology it had at the time, what it can do. So I don't know about that one way or the other. Obviously, that would be, if that car had an internal GPS that still retained the evidence of its position that night, to me, that would obviously be extremely probative evidence for either guilt or innocence, right? So, but we haven't heard anything about that, and I'm no expert on an Elantra of the year that he had, so I cannot tell you that he had a GPS system in it, and then if he did, whether it actually was recording where he went, because depending on what your car is doing, it may be recording things, it may be transmitting those things, or may not. There's the allegation by the state that he turned his phone off at that time, and if he had his phone on and it showed him innocently driving around, between 2 and 4 in the morning, then the defense team would be able to say, well, he was at this place and this place and this place, if they had that information from the phone. But his phone, the state says, was turned off at the relevant times, and they don't know exactly where it is. So I don't think it's a strong alibi. It's kind of worse than the last one they did. Maybe they should have left it alone because again, he has the right to testify on his own behalf, even if he's violating this alibi rule. He just couldn't use other people to do it. But I guess they were maybe a little bit worried that they might lose the ability to try and establish an alibi through cross-examination of some other people if they didn't advance this ball a little bit. Now, look, that's different. That is different than challenging the state having to prove he was at the crime scene, right? That he did this, right? So they do have to prove that. They have to prove that he was there. If they don't prove he was there, then whether he has an alibi or not, it doesn't matter. That's their burden to do. So his team certainly has the right to challenge that they, that not, maybe we can't show exactly where he was, but they can't either. That's got to be part of their story, is the state has the burden of proving he was there. Now, there's DNA evidence in this case. The video on that maybe wasn't so interesting because not many people watched it, but I did go over the study of how secondary transfer works, which is a positive for the defense, and how, nevertheless, at least what has been reported, may mitigate against the usefulness of that for the defense and show that this evidence is significant for the prosecution, which is how I currently see it. But it's early in the case. So I got to get to this next slide because I got Taylor Schabusiness just staring right at me, and that's not a good thing, I don't think. Well, we all know that she was found guilty, right? And it's now down to the sentencing phase. And hopefully everyone can see that evil, bizarre, weird, crazy things does not equal legal insanity. I think most everybody knew that already, but nevertheless, the term insane for legal purposes is not a medical term. It's not even a street term. It has a very specific definition. And voluntary drug use, which was present in this case, is typically bad for the defense when it comes down to the insanity defense. It can help in a diminished capacity situation, but that was not what was going on here. This was her attempt to use meeting the definition of legal insanity, mental disease or defect, to not be responsible for the crime, and the jury didn't buy it. Interesting here was this attorney inherited this case after she attacked the last attorney. I wondered tactically, she pled not guilty, that she didn't do it, right? Or they couldn't prove she did it. So they had to go through phase 1 of this trial with this jury, with the ridiculous idea that the jury wasn't supposed to conclude that she did it when she obviously did it. So then you carry that into phase 2, and the same attorney has to stand up for the same defendant in front of the same jury. And what credibility do you have there to say that she was crazy at that point? Now, you have the evidence and stuff, but you'd like to build up credibility with the jury. And I think if you've disputed that she did it or whatever, then maybe you don't have a lot of credibility coming out of the gate for your next proposition and now you have the burden in phase 2. So I don't think that was up to him or a choice, and I'm not second guessing what he did, but maybe if you're going to say I was crazy at the time, you shouldn't also say, but I didn't do it at the time. You see the inconsistency there? Whatever. All right. Let's see. Lori Vallow watched her, or I listened to and then streamed her side of her sentencing hearing, which ranged from strange to really strange. First, her attorney patting himself on the back for the noble cause of being a public defense attorney, which I think is noble, but not more noble than what the other people were doing in this case and having to deal with. So that was a little weird. To her speech about how Jesus knows her and basically saying everybody that got killed is better off for it. They're all busy and have jobs in heaven with great benefits. And they've all come to me and said, don't even worry about it, bro. We're great. So unfortunately, the judge did not receive the same visit, unfortunately for her. And he found that she's getting life without parole and poured a little bit of water on the loin fire. Now, for you or me, that could be substantially bad, right? That's terrible, life without parole, but not for her, because she and Chad travel across thousands of years, meeting each other under different environments at all times. So having to spend a few years in prison apart from each other is nothing in the grand scale of their unique godlike existence that they say they have. So the good news for her is this is just this life without parole. It's not every life without parole. So as she continues to come back into existence as part of God's plan, well, she can just pick up next time with him somewhere else. So that's the good news for her. But at least as it regards this life, it's pretty much over. Now, she does have a next stop in Arizona where she's going to be, I think, extradited to face the charges there. Chad's Idaho trial is in 2024. I think maybe that was like May or something like that. So it's a while before his trial comes up. But I can't see him getting a better result than she has. But again, while the loin fire in this lifetime is diminished, they can fire that ember right back up later on. Now, what was interesting in this case was, mental condition is not a defense to a crime generally in Idaho. They don't have the insanity defense, say, like was available in the Shabusiness case. It can be a defense to intent. So if the state is charging you with specific intent and you can show that you were so bonkers you couldn't form that intent, it can be a defense to that, but it cannot be a defense to crime generally. However, it can be a consideration in sentencing. So if you're found nuts, then the court would order you for treatment, and that may be even at a different facility than a jail. But what's interesting is once you're cured of the nuttiness, then you are still liable for the remaining sentence. So you can get the treatment that you need, but you're going to have to serve your sentence because that's the way they do it in Idaho. The state that wants to bring back the firing squad, but we'll see about that. Let's see. I think Arizona case is one of them is an ex, isn't the other? Is the other her brother? I'm not sure. I haven't looked into Arizona stuff too much. The question about death penalty in Arizona is they do have the death penalty. They did get a couple, I think 3 people executed in 2022 after a dry spell. But the new governor has said, hey, we're stopping all that. We're putting another review on it. So it's like the death penalty everywhere. Whether you're for it or against it, I think you have to admit that the system is a total mess because it just is. But yeah, I think Lori has gone off the deep end. That's for sure. But I don't, in terms of her staying in prison forever, I don't feel sorry for that at all. That's where she needs to be. And Idaho being the compassionate state it is, if she needs some kind of medical treatment, then maybe she'll be able to get it there, but she won't be able to come out in this lifetime and do anything else because she participated in the vicious, horrific murder of her children for financial gain and to make her personal life better, and the murder of an innocent woman so that she can take the husband. So the fact that she gets to continue to breathe is a luxury and mercy for her that I don't personally think she deserves, but society gives it to her, and I respect that. This dude right here is another case, Ethan Crumley. So he's in a Miller hearing, and that's gone on for a few days, and it's not over. They're going to have to reconvene it. I guess they ran out of time that the judge had scheduled for it. And he killed 4 classmates, injured people in a school shooting. And the Supreme Court says for life without parole for juveniles, that the judge has to take into account differences between children and adults and how that counsels against irrevocably sentencing them to life without parole. So that's what the judge is doing. He's listening to the state's evidence, the defense evidence to make a determination of whether this kid ever has a chance to get out or not. And in fact, the Supreme Court has earlier said that there's no life without parole for juveniles for anything less than murder. And then in murder, you have to have this special hearing. So anyway, what's weird about this one, or got weird for the parts of it that I heard, were not only some serious fail going on the defense expert side when the prosecution caught the guy using parts of an earlier report from somebody else, were just how evil and twisted this kid's mind became. And I don't know why. I have no idea why. But while he fantasized a lot about killing his classmates for the purpose of causing them and their families pain, right, and to become famous himself, and with a specific plan to surrender when the police got there so that he wouldn't be harmed, he fantasized about that a lot, shooting people in the back of the head, and he did carry it out to the degree that he could. What's really awful about that is before that, he was torturing little birds to death, and his commentary on that, I have to think it's worse than Jeffrey Dahmer. If you didn't hear it, it's one of the most disturbing things that I've ever heard in my life, because of the specific joy that he would take, that he said he took, of making these animals suffer in the most horrific ways that he could come up with, and the joy he took in snuffing their life out. And again, I don't know why he's like that, but it was really, really awful. Now, the picture above him, that's a picture of his parents. And of course, they're facing trial for involuntary manslaughter because they bought him a gun. And then right after they bought it for him, they left it accessible for him. Then, of course, he took it and killed everybody. And the question really is, should they be held responsible for that? And that's a complicated question, because how, I guess, is the answer to that. You could sue them in a civil suit, which I think they have been, although I don't know if they're taken out of it or not, because I don't know if they have anything. But there's multiple statutes at play. And, you know, I was listening to Dave from Michigan Law Show talk about proximate cause on this, because I don't feel sorry for these parents at all. I mean, I got a lot of guns, been around guns my whole life. And I think if you know your kid is hearing demon voices and things like that, and you leave a firearm accessible to the kid, that's very irresponsible. But he makes an extremely good point about the ramifications of that thought process for the normal rule of proximate cause, where the intentional act of a third party would break the proximate cause chain. And I respect that. And his point is that even though Michigan doesn't have a safe storage law like they did in Virginia, and the lady there was charged when her kid took a gun to school and shot somebody, and I think she's pleading guilty to some of those charges, that they also had other charges in Michigan they could have pursued that he felt would be more accurately addressed toward this case. So I get that. Now, the Court of Appeals right now has said, no, you got to go to trial, parents. So, you know, they're going through it. And so I think there's more than one way to look at it, but I understand the point of view that involuntary manslaughter is at the limits of the law and maybe beyond it in terms of the normal rule for this kind of activity. But they're not people I feel sorry for. It's just strictly analyzing it from a legal aspect, and, you know, how this really should play out to have consistent application of statutes across consistent behaviors and consistent rules. I get all that. Yeah, as parents hid from the cops, they knew they did wrong and are accountable. I mean, I don't disagree with it. Again, I don't feel sorry for them and all that. And I didn't hear Dave say no, these people are great. These people didn't do anything wrong. I mean, he said they were very responsible, but I think he feels like there are other statutes that could have been used against them that didn't require the stretch that this one does. Because again, well, I get where the Court of Appeals is coming from. Even the Court of Appeals in their decision said this decision cannot be used as precedent for decisions in the future. And when you have a criminal case and you have an appellate court saying, here's our decision here, but you can't use it again in the future, you know that they have pushed the limits of, because why can't you use it? If it's following the normal rules of criminal law, and then it should be just something that helps explain to the future. And that's what appellate court decisions usually are good for. So even they knew they're at the very limit of this thing. Again, I don't feel sorry for him, but I understand his point that maybe a different charge would have been the appropriate way to go. So if you're interested in that point of view, obviously check out what he has to say. And he talked about it a little bit last week on the Laid Back News broadcast we do at noon. And I'm sure he's talked about it on his channel and some too. So I get what he's saying. And because he laid it out very reasonably, I certainly respect his point of view. But some very bad facts in that case, I think. So all right, let's go into the poll vault. And we did one this week for retrial after appeal. And this had the Bonnie and Clyde scenario, totally random names, of course. on trial for murder in separate trials. At Bonnie's trial, she was found guilty of second-degree murder, sentenced to 10 years. Clyde was found guilty of first-degree murder and sentenced 25 years. They both appealed. They went on some evidence thing. Comes back, and she's found guilty of first-degree murder, and then he is found guilty of the same first-degree murder and gets a higher sentence. Now, I put the delay on her sentencing because I didn't want the sentencing to be any factor in this. But some people said, well, maybe that delay could be a violation of her rights. So, and sometimes it could. So I can't say if your decision is different than mine that you're wrong in that regard, or if you imagine some other issues that I wasn't trying to aim at here that you're wrong there. And specifically, every state, as I say in all these broadcasts, has different laws. So I was really talking about federal constitutional stuff here, but states can expand the rights of people under that or even have different things. They just can't have less. But let's get to the answers. So I'm in this first pool of 12% here that Bonnie wins and Clyde loses. But you can see the vast majority of people say that neither of these appeals win or they don't know, which is a good answer in this case because there's pretty obscure points of law. And I'll explain to you why I think that. So we did a member stream on double jeopardy, and that's why I got this scenario in my head. And we went over that. So any member that voted here hopefully got the same answer I did, or maybe it was too boring to contemplate. Anyway, we did it like we do on these member streams where we go deep into specific topics. And here we'll hit it a little more generally so you know what the rules are. So basically double jeopardy is the United States rule that says you cannot be put twice in jeopardy for the same offense. Now, some forms of mistrial do not count. If the defendant appeals, it usually doesn't count. So if it's on some evidence thing or something like that, not misconduct to the prosecutor, but decision by the judge or whatever, and it gets reversed, the person can face trial again. And that's not considered double jeopardy. It's kind of considered a continuation of the first jeopardy. And you could be retried more than twice, 3 times, 4 times. The double jeopardy rule is not really protecting you there. Now, when does jeopardy start? The first jeopardy, because you got to have a first jeopardy before you can have the double jeopardy. First jeopardy starts at the time the jury is sworn in, if it's going to be a jury trial. So if charges are dismissed and things like that before a jury is sworn in and they get reinstated, that's not a double jeopardy violation. If it's a bench trial, it's when the judge takes the first witness. So that's some quick general rules there. All right. Let's see. In the Clyde case, I'm trying to read some comments too here. So in Clyde's case, he got a higher sentence. Now, a higher sentence is not an issue, but believe me, there were cases about it. Like if you get sentenced to a higher sentence, are you facing a double jeopardy for what you did originally? Because it's not just the verdict that's being overthrown, but the sentencing. But the courts basically said, nah, you put yourself at a risk for a higher sentence if you voluntarily appeal. It's just how it works. There's an exception for that for capital punishment, or if you can show the judge was like, well, you made me do this twice, so I'm going to give you 5 more years. Obviously, that would be wrong. But generally speaking, his increased sentence would not be a reason for him to succeed in another appeal. He was found guilty of first-degree murder and guilty again after the first successful appeal, so he's probably out of luck for the facts as stated. What about Bonnie's case? So if she were charged for murder generally, of course, usually the jury has a choice, first-degree murder, second-degree murder, all that kind of depends on the state that you're in. But if it is like that and you were found guilty of second-degree murder and then you appeal that and the verdict gets thrown out and you go back for retrial, the rule is that there was an implied acquittal of the higher charge. That if the jury came back guilty on second degree, it meant they found you not guilty on first degree. So now when you come back for trial, you can't be tried at the higher level, the first degree level. You have to just be tried at the second degree level or lesser included under that. So that's how that works. Now, if the jury deadlocks on second degree, there was a case that said, well, what if they deadlock on second degree? That's an implied acquittal on first degree because they wouldn't be deadlocking on second degree if they thought there was any chance for first degree. But the court said, no, we're not going to imagine that an acquittal. There has to be a verdict rendered. But if there is a verdict on second degree, they can't go back for first degree. All right, so let's see. Well, Australia doesn't have the death penalty. It's thrown out in 1936. And, of course, ours comes and goes and changes in many ways. And it's hard to say it's unconstitutional in the abstract because there are death penalty things in the Constitution. And then also they were doing it then. So they have to sometimes find, well, this way is too cruel or it's too arbitrary or whatever, which can certainly be true. But with 50 states changing leadership all the time and the federal government changing leadership. It just comes and goes here. So the death penalty is a hard topic for Americans because of how it's so different everywhere. Well, I think that's it for this one. And let's see, unless we've got any questions. And I don't see any on that, but that's the updates we've got. There'll be some bigger updates coming on some of these cases soon because the Kohberger motions are all coming to a head soon. Of course, Brooks will be back in court, and we'll find out if he's going propane or profane or whatever he's going to do. And the many other things. Sarah Boone's case will come back up, etc. But for now, nothing happened on that. So let's see. All right. You guys are talking about Darrell Brooks, that guy. He's unfortunately a fascinating, weirdo, evil presence that it's like a terrible thing you can't look away from sometimes. But that's it for now. Everybody have a great weekend, and I'll talk to you later. If you're around at noon on Layback News, I'll see you then. And that's it. Thanks. Bye.